Sounds bat crazy.
Oh.
Bat crazy. You don't live in someone's house for free. You show me where you paid the rent or that you have a lawful reason, not some cockamamie story you didn't came up with.
Put you down. You know, you're 19. Do something with your life. Don't become a statistic.
This is E3 Investments LLC versus Zachariah Latney, 26-01434. Appearance, please.
Attorney Catherine Gable, P81555 on behalf of the plaintiff.
Your name, sir?
Well, I believe the caption is Zach Latney.
It says Zachariah.
Zach Latney.
Okay, your name's not Zachariah?
My name is, as it appears on the lease, is Zach Latney.
No, I don't know. I'm asking if what was filed is correct.
Yeah, Zachariah Latney.
Okay, thank you. And you don't have an attorney representing you, correct?
President.
Okay, you have not been able to come to resolution. This is for non-payment of rent?
No, Your Honor, we have not. I tried to speak with Mr. Latney earlier, but we have no resolution.
Mr. Latney, you believe that you have a lawful reason to withhold the rent?
Yes, Your Honor, the equitable defense is cited in the answer, which should be on file with the court, Your Honor. Which can be elaborated upon today.
Okay, you can have a seat. You can call your witness.
Thanks, Your Honor. Plaintiff's call Eric Romano to the stand.
Oh, if you can get their exhibits out of your way.
May I approach?
Yep, thank you. You can raise your right hand, sir. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. State your first and last name within spell both.
Eric Romano, ERIC-ROMANO.
You can proceed, though.
Thank you, Your Honor. Mr. Romano, are you the owner of E3 Investments?
I am.
All right. And Mr. Romano, does E3 Investments own the property located at 1130 West Mount Hope in Lansing, Michigan?
Yes.
Okay. And what is your role at E3 Investments, Mr. Romano?
I'm the owner, president. It's me, just me.
And on September 22nd, 2023, did you enter into on behalf of E3 Investments, enter into a monthly rental agreement with Mr. Latney?
Yes.
Okay, may I approach?
Right.
Mr. Romano, I have placed in front of you what is entitled monthly rental agreement. Is that correct?
Yes.
Okay, and is that the lease that you executed with Mr. Latney?
Yes, it is.
Okay, and can you please tell me when the lease began and when it ended?
September 22nd, 2023, and it's a month-to-month lease.
And when does the term of the lease begin each month, Mr. Romano?
On the 25th.
And when does the term of the lease end each month, Mr. Romano?
On the 24th of the next month.
Thank you. How much rent is due per term?
$1,100.
Okay, and does the lease call for late fees if rent's not paid within 7 days?
Yes, it does.
What is the late fee amount?
$50.
Okay, Mr. Romano, has Mr. Latney paid rent for the term August 25 through September 24?
No.
Has Mr. Latney paid rent
August 25 through September?
August 25th through September 24th? Sorry, it's a 30.
Okay.
Yeah. So, okay, the answer is no.
I think I knew what you were saying, but was you thinking years at least?
Yeah.
Got it. Got it.
Okay.
I'll clarify.
He's thinking you're talking about 23. You're talking about the term. I know what you were saying, though.
Yeah, I apologize. So Mr. Latney did not pay rent from August 25th, 2025 through September 24, 2025, correct?
Correct.
And has he paid rent for the term beginning September 25th, 2025 through October 24th, 2025?
No, he has not.
Okay. And has he paid rent for the term beginning October 25th, 2025 through November 24th, 2025?
No, he has not.
Has he paid rent for the term beginning November 25th, 2025 through December 24, 2025?
No, he has not.
Has he paid rent for the term beginning December 25, 2025 through January 24, 2026?
No, yes, no.
Has he paid rent for the term beginning January 25, 2026 through February 24, 2026?
No, yes, no.
And has he paid rent for the term beginning February 25, 2026 through March 24, 2026?
No, yes, no.
Okay. And has he paid rent for the term beginning March 25, 2026 and ending April 24, 2026?
No, yes, no.
Okay. Mr. Romano, have you kept the premises in good habitable condition
Yes,
and good repair?
yes.
May I approach?
Man,
Mr. Romano, what I placed in front of you is entitled Payment Record. E3 Investments v. Zachariah Latney. You recognize this document?
Yes.
And Mr. Romano, can you explain to the court what this document is?
It's a ledger, a payment record showing rents due and late fees approved.
Mr. Romano, what is the balance for rents and late fees due today?
$9,200.
And is that payment record a true and accurate reflection of what is due and owing under the lease with Mr. Latney?
Yes,
Objection.
what's the objection to?
Just not receiving this, and that amount is not encompassing the original complaint.
You said not receiving the ledger?
Yeah, I'm just not receiving this. Is this being submitted?
I don't know. She not,
I'm going to move to admit it as
Okay.
Exhibit 2.
okay.
Okay, the amounts asked upon are inconsequential because they don't encompass that which is encompassing the original complaint.
You're saying that it's larger than the complaint?
Yes, ma'am.
You do understand that as the time progresses, the amount increases, correct?
So you're saying that,
Yeah, like, for example, if I
no, I
continue,
understand the question.
if I continue this until next month, May 1st, the amount's gonna grow.
Precisely, okay, so the question then becomes, to what extent do those amounts? So essentially, that which is originally
Your
complained upon.
objection to the exhibit.
The exhibit is that he never received it,
Yeah, I never received it.
and that he says that
I'm
he
just not
thinks the
receiving
amounts
those.
are,
That is a clear objection I'm having.
the amounts are off.
Yeah.
I'm gonna respond and say that's not an objection. It's an exhibit that's going to be admitted, and if he wants to ask questions about it, he can do that when it's his turn.
Okay, it's a copy of a ledger that you keep in the regular course of your business?
yes.
Okay, objections overruled, it's admitted.
And I'm sorry, I guess I need to retract. I would move to admit the lease as Exhibit 1.
And it's admitted.
Thank you. All right, Mr. Romano, again, I'm sorry, just for clarification, how much is owed for rent and late fees as of today?
$9,200.
Okay, and Mr. Romano, does that ledger include any court costs in that $9,200?
No,
Okay. And as to court costs, Mr. Romano, is it correct that you would be seeking those costs in the judgment today?
yes.
Okay, and no further questions, Your Honor?
Do you have any questions for the
Yes, Your Honor, I
witness?
do.
Proceed.
Allow me a brief second. Cross-examine the witness.
Okay.
Can I get my questions together? Is that an issue?
No, I just told you you can
Oh, no,
cross-examine the
it seemed like
witness.
she had a complaint. I'm just like, what's the issue? All right, okay. What date did, okay, this is gonna be my question. What date did you allegedly engage in the lease with the plaintiff, Mr. Romano?
He
I mean,
is
with
the plaintiff.
With the defendant, Mr. Romano? Excuse me.
Jack, that's asked and answered, but go ahead.
He has answered that already.
The 22nd of September, 2023.
Okay, these proceedings, on what date did your attorney file, the complaint initiating these proceedings?
That I don't know. I can refer that question to my attorney.
So I can take judicial notice of when it was filed. I have it.
Gave me the court.
It was filed with the court, it looks like on February 20th, 2026.
Okay, all right. February 20th, 2026?
Correct.
Okay.
Actually, February 23rd is the stamp on the side, but it was dated by the attorney February 20th, 2026.
This action was filed?
That's when the complaint was filed.
Thank you, Your Honor. I do have more questions on point and which are relevant. Okay, I wonder for the record, is your phone number, Mr. Romano?
But you don't have to put it on the record. His phone number. You can ask the last 4 digits if you want to confirm.
Thank you, I appreciate it. Does the last 4 digits of your phone number end in 9908?
Yes,
And did you text the defendant regularly for means of communication by way of payment to be received from you, from the tenant?
yes,
So you and the tenant regularly texted with that phone number ending in 9908?
yes,
Okay. Prior to initiating this suit, did the tenant text you respecting amounts owed and that were paid to you?
I'm sorry, can you repeat your question?
Prior to your attorney initiating this suit, prior to counsel initiating this suit, did you and the defendant communicate regularly by way of that phone number ending in 9908?
yes.
Thank you. Okay. One last question. A few more questions, Your Honor.
Take your turn.
Thank you. Do you recall communication taking place between you and the defendant on or about March 4th of this year, 2026?
No, I don't.
You don't recall?
I don't recall it.
Okay, so you don't recall a text message taking place between you and the defendant wherein the defendant gave you formal notice by way of text message?
Objection has to be answered. He said he doesn't recall the messages.
Okay, no problem.
Objection sustained.
Quick question for you. Are you aware of any text message that took place between you and the defendant on March 15th, 2026 of this year? Is it your response to this question that if...
He said no.
No. Okay,
okay.
follow up, please.
Yeah.
Okay. You're not aware of any communication that took place. Since you're not aware, this is my question, since you're not aware of any communication that took place on March 15th, 2026 between you and the defendant, there would be no cell phone records wherein confirming you received the same?
Are you asking me, are there cell phone records? Because he's saying he's not aware. He's not saying it didn't happen. He's just saying he's not aware.
He's not aware, okay. My question is that because he's saying he's not aware, that there would not be any cell phone records affirming that he's actually read the messages which he claims he's not aware of.
Are you saying that no conversation took place, or you just don't remember?
I'm saying I don't remember.
Yeah, so he's not disputing that there was text messages.
Okay.
He just doesn't remember.
Are you aware that on March 15th, 2026, you were expressly appointed as trustee privately by the defendant?
I'm not aware of it.
Okay, you're not aware of that. It's fine. Just give me a second. See if I can get anything more relevant for the witness, and I'm gonna let him go. Okay. Oh, yes, this is actually very poignant. Prior to you and the defendant engaging in a lease, did you require any criminal or background check for the defendant to engage in? And was there any documentation that you took to that effect?
Do I
Objection,
require it?
compound, and form.
Compound meaning you asked 2 questions in one, so can you break it up?
Sure, no problem. So I can like.
You can rephrase it, but only ask 1 question at a time.
No problem. Prior to engaging in the lease, which is subject to this underlying suit, did you and the defendant engage in a creditor background check?
I don't remember.
Is it your testimony today that you never required a social security number to be provided by the tenant?
I don't remember. That was 2.5 years ago.
Okay, so with text messages,
I'm gonna object as to
He
relevance.
doesn't remember, so you're going to have an opportunity to give testimony. If you want to share any of that, you can do that.
no problem.
You don't got to get him to get it out of you.
No, that's,
Yeah.
I'm just,
He said he doesn't remember, so he's not
I
disputing
gotta lay a
it.
foundation though. Something.
No, you don't. If you want to tell me all that during your testimony, we'll allow.
I don't know if he doesn't remember unless I ask Your Honor.
I get it, but him remembering or not, it really has nothing to do with whatever point you're trying to make with that.
What if he said he remembered? It would actually affirm the point I'm making, is what I'm getting at.
Okay, well, he said he doesn't remember,
No problem.
and you're trying to re-ask him in another way. He's not going to change his question
No problem. Okay.
or his answer.
That's the witness, Your Honor. I'm done.
You can redirect if necessary.
Your Honor, redirect is not necessary. Thank you.
Any other witnesses?
No, Your Honor.
Thank you. You want to give testimony, sir?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, I do, Your Honor.
Thank you. Tell me why you believe you don't lawfully owe rent since September of 2025. I'm sorry, August 25, or is it?
It's,
Well, I guess it's September 25th of 2025. You haven't, the testimony was you have not paid rent since September 25th of 2025.
Yes, Your Honor.
So tell me why you lawfully can withhold rent, or why you believe that.
Well, first and foremost, I would direct the court's attention to the answer, which is on file.
You have to tell me your reason. I've read your answer, but that's not evidence.
Okay, no problem. I'll give you, okay, so on March 15th, let me give you the whole layout since I'm on the record and I can get it all out, right? Let me get it all out and I'm going to testify. I'm giving my testimony right now. So prior to engaging in this lease with Mr. Romano, he required, and I have text messages to that effect, which he's received, he's read, but it's okay. I have text messages to that effect between me and him, wherein prior to engaging in this lease, he specifically required a social security number.
Okay.
And in requiring said social security number, it was for the purpose of a credit or background check. Said social security number was reflective of the principal obliger on the lease. This is antecedent to the lease that is signed and in the record and encompassed in her complaint. Okay. Said social security number that was taken from him is not reflective of myself. It's not reflective of myself with respect to being obligated regarding the same. This is just a primary claim that I'm making. I have a secondary claim, which is an equitable defense, which is layered onto this. Just bear with me. I'm not in court.
I'm listening.
Thank you. I appreciate it. He was noticed of suretyship and subrogation rights with respect to the social security number taken and reflective of the principal obliger on the lease. He was noticed of a legal distinction being made with respect to the principal obliger and myself, as a matter of fact, by way of documentation provided to him in these text messages. Not only,
Are you saying that was the nature of the text messages you sent in March?
yes, Your Honor, I am. That's precisely what I'm saying.
Okay.
Actually, these text messages go back to February. Secondarily, with respect to the suretyship and subrogation claims, to which I stand as subrogee to the principal obliger underneath the lease, to whom I stand as subrogee with respect to the principal obliger on the lease. Him being the creditor or the subrogor, he was noticed that my suretyship and subrogation rights were transferred to him in trust for my sole benefit. What I am saying is, prior to even showing up to that first hearing 2 weeks ago, he was noticed of and read text messages wherein he was expressly appointed as a trustee and owes me fiduciary duties as sole beneficiary prior to initiating this suit. That is my purely equitable defense that I'm asserting here today.
Okay.
As a result thereof, and as a result of those allegations of fact, which bear on this immediate case, Mr. Romano and E3 Investments LLC, by way of a trust indenture, which I can show this court and my phone number, stands with respect to me as my trustee. And he owes me a duty of undivided loyalty as my trustee, as is my allegation of fact today. And I am the sole beneficiary with respect to that trust that I can provide the court. He owes me fiduciary duties and a duty to account with respect to that which he was entrusted with, specifically and prior to engaging in these proceedings. And he was noticed of that. Not only that, but as sole beneficiary, equity regards me as the true owner. And my sole defense right here and now is that he stands in relation to me as a trustee and a fiduciary, owing me duty sacred in equity, to which I can't freely enforce in probate court. And as this court has been made aware of, this court doesn't have jurisdiction over those exclusively equitable claims of beneficiary of trust relations. But that is my equitable defense that I'm asserting here today, that he was granted a fund in trust, that he possesses said fund, and that as fiduciary, he owes me a duty to account as sole beneficiary. And that said accounting that he owes me directly conflicts with the legal relations that he has as landlord in this underlying suit. And I am now asserting there is a conflict and variance between the rules of equity and the rules of law with respect to the same matter. And that owing me an exclusively equitable duty of trusteeship.
That said he owes you a duty of trusteeship?
Yes, he does.
Okay. Any other argument for why you think you can live in his property for free?
He's been granted the fund to which he must account. These are equitable rights.
You granted him some funds?
Yes, I granted him the
Where?
fund. By the way, I'll show you right here. Got you right here, Your Honor. Got you right
Show
here.
his attorney where the funds were sent to her client.
Are you? Is the court saying, as a matter of fact, that he's not?
Show me where you're gonna show me evidence where you sent him the funds.
Yes.
Show him to the attorney first, where he was sent his funds.
Got you right here. Got you right here. Give me 1 second. I'm just pulling up the text. You're gonna see it says red right next to it too.
For clarity, Your Honor, if I may, this is rent payments for the
Correct.
money we're claiming due and owing.
Those are the only funds I'm looking at.
Not previous. Correct.
So,
Okay,
is
just
this
for
court
clarification.
asserting that I did not have that equitable defense asserted is not relevant?
Well, let me be very clear here. I read your answer and I gave you ample opportunity to make a record here. I don't really know if there is an underlying issue that requires a competency evaluation, or if you Googled something that made you think that these things were lawful reasons to live in someone's property and withhold rent. You speak over me, you will be remanded for contempt in court. I don't know what's going on, but none of the things that you say or have said in this courtroom as it relates to a lawful reason to withhold someone's rent makes any sense. For you to sit here and vehemently assert that the landlord, after telling you that you are filing a notice to quit and vacate his property for failure to pay rent, now owes you some duty other than to collect the rent from you, sounds bat crazy.
Oh.
Bat crazy. You don't live in someone's house for free. You show me where you paid the rent or that you have a lawful reason, not some cockamamie story you didn't came up with. Your answer looked like you cut and pasted something from a probate court proceeding from probably a sovereign citizen, crossed out what you didn't think applied and signed your name to it. We don't run circuses in here. This is a courtroom of law. Do you understand me?
May I respond?
If you have proof where you paid rent, show it to her. Otherwise, judgment for the plaintiff.
Your Honor, may I respond?
Do you have proof?
I'm trying.
Do you have proof?
You asked me to do two things.
Well, I ask you one thing. Ask you one thing. Do you have proof?
Yes, I do.
Show her the proof.
Got you right here. I was in the middle of getting that earlier, but
listen here. Show her the proof because she wanted to clarify what you were about to show her. Okay. I don't want to see no text messages of no. I notified him of some trust that don't work here. We're not dealing with trust. We're not dealing with probate. We're dealing with possession of property. You signed a lease.
I know I'm at law.
You signed a lease. You agreed to pay the money. I don't care if he did a background check or if he didn't. Well, I don't care if you gave him your social security number or if you gave him your telephone number. You agreed to pay this rent. You've been holding over his property since August of 2025. And I want to see proof that you either have a lawful reason to withhold it or proof that you turned it over and he's just mistaken.
Okay. Thank you. Thank you. My mandamus gonna go in tomorrow too. Don't worry.
You can find a mandamus or anything else you want to file. I really do not. I promise you, I don't care.
That's okay. So it's a quite lengthy text. That's why I'm trying to find it. But I'm.
Is this evidence of you sending his past due rent?
Yes, he's in possession.
Okay.
He's in possession of it. Yes.
You can show the attorney for her review.
Yes, 100%. And I'm standing on my equitable offense regardless. What are you reading right there?
It says declaration of trust and appointment of trustee. There's no
judgment in favor of the
Thank you,
plaintiff.
Oh,
You can be excused. Bye.
Yeah, I know. My mandamus going in too.
File whatever you want.
Yeah. Yep.
You have paperwork.
I do, Your Honor. Is it the possession 427?
The writ date
Yes.
is the 27th.
Thank
That
you.
is correct.
Your Honor, do you need to prorate rent on the record or amounts due for the
Yes,
money judgment? Okay. For possession, Your Honor, he owes $8,800 in rent plus $400 in late fees plus costs in the amount of $174.80 for a total of $9,374.87. And for the money judgment, Your Honor, which has been prorated through today at $36.67 a day. Rent plus late fees is $8,870.07 with costs of $174 It's $174.87 for a total of $9,044.94 for the money judgment.
Thank you.
You're welcome.
Any additional matters for the record?
No, Your Honor.
I think I've earned a recess of 5 minutes.